Hi, it's Anne-Marie from Charmed Live Therapy. I'm looking very dark and wintry today. Well, it's time to get back on with another update. She says, clearing her voice, another Baldoni lively update. I know I kind of have been quiet for a couple of days, but I think things were well covered. I think the most thing going on, the most interesting thing, of course, was Blake's little loss, if you want to call it. Um, and I think this kind of demonstrates where Blake's head is at, in that how many times now is she not getting anywhere with this idea of subpoenaing people in order to bolster or create her case? And I think you can see what Justin and co have always been dealing with. There's a certain resilience that comes along with being a narcissist, where you can cope with an awful lot of knockbacks because it just feeds into that thing of the whole world being against you and having to fight on for the good of the cause and all of that. So she went to all the trouble of getting sourced intelligence, the line of Friedman company. She went to all the fuss of getting that transfer from California to New York. And I think it, when you read the things that are taking place in other parts of America that are related to Blake Lively and her wanting to bring it back to New York, if I was Judge Liman, I would be getting intensely frustrated because it almost seems like going across the country wherever she's been targeting people, or even in Canada to do with some of the content creator subpoenas, it's been like, I have a pet judge in New York, and I think we should transfer it to my pet judge in New York because he understands my perspective. Blah, blah, blah. If I was Judge Lyman, I would be kind of annoyed that all across the country and well into Canada, certain judges are getting the impression that Blake Lively considers him her pet judge. I would be feeling a little bit irked about that. Well, anyway, he has denied. So sourced intelligence got themselves dragged all the way to New York, or the case did, at least. This motion to compel them to respond to the subpoena for all the private information that they had between them and their client, Lina Friedman, vice versa. So yeah, it got denied. It was like, no, that's attorney-client. And also, it's like, come on, Blake, because now she's saying that the smear campaign started during production of the movie, which just makes little sense, as we all know, because we all know how a movie can be tanked if the wrong person gets the wrong press at the right time. We're seeing it literally right now with Stephen King and his comments regarding, he misquoted Charlie Kirk or whatever it was to do with stoning homosexual people. And people came down on him like a ton of bricks. And it was like, don't go see that movie, The Long Walk. It happens. You do not tank yourself by attaching negative publicity to your production before it ever even comes out. What would be the sense in that? But that is how far adrift, how far removed Blake Lively is from reality. That like it wasn't working, that it started from the premiere. So now it's starting during production of the movie, the smear campaign. How many times has it switched to who is the source or who is the mastermind of the smear campaign? Is it the Skyline Agency? Is it Jed? Is it now these people sourced intelligence who can do dark ops on the dark web or whatever the hell it is? It's like, come off it. When are you going to accept reality? But this is what we see time and time again. It doesn't matter how many of these, Perez won his subpoena battle. I imagine Andy from Popcorn Planet is going to win his subpoena battle. Every content creator that had to represent themselves pro se seems to have won the subpoena battle against it, or it's been withdrawn. There may be some that have slipped through that we don't know, that we aren't as familiar with, I guess. But yeah, So Judge Liman says no, sourced intelligence does not have to give you the information, the conversations, whatever it is between them and Lina Friedman, who hired them at the time the lawsuit came into play. You don't get to. I tell you the one thing I did find frustrating about that, that in his brief, his reply or whatever, I won't get the specific wording accurate, but it was basically speculation is not enough to compel discovery. So her speculating that sourced intelligence, I think the word she used was may have orchestrated something or other. He says, no, that's not good enough. But it's like, well, it's like really kind of a bit insulting to all the content creators that were subpoenaed to say, well, you've dealt with this company, sourced intelligence, and you've said speculation is not enough to warrant compelling discovery. Why were you not on the case for the content creators who were having to represent themselves, who didn't have a fancy law firm behind them? Why didn't you step in and say to Blake Lively, you had plenty of content creators telling you they were uncomfortable with this, they weren't happy about it, they wanted sanctions. Why wasn't he stepping in and then saying, speculating that these people may have had is not good enough to warrant but he just wanted that whole thing of, oh well, she's withdrawn it now, so it's all moot. So that was entirely frustrating, because really he should, my feeling is, Liman should have been a whole lot more proactive on behalf of the content creators, I think. So what is going on? So she says so, word of the day. So what is happening is on October the 6th, Wayfarer are going to have the opportunity to depose Justin Greystone, who is Blake's manager. So they've been negotiating with him as to when they're going to depose them. And what we've got now is Wayfarer's opposition to Blake's motion for treble damages. And I don't have all the documents because some of them haven't been released or they've been sealed. But what's going on is that Wayfarer have had the opportunity to depose Vivian Baker, who's Blake's makeup artist, Warren Zavola, I believe, who's Blake's talent agent at WME, and Danny Greenberg, who is Justin's former manager at WME. So Blake wanted some of those elements of that deposition to be marked confidential, unsurprisingly, one would think. So yeah, there's parts of that, those depositions, that are attached to Wayfarer's opposition to a motion for treble damages. So let's go ahead and look at that and see if we can make sense of it. I haven't had the chance to go through it properly, so I'll be doing it at the same time as you. So let's take a look at it. Right, are we on the right one? So that's Ellyn's declaration. So we'll read that first because it'll be a quickie. So I, Ellyn Garofalo, I am a partner with the law firm of Lina Friedman, attorneys of record for Wayfarer and parties. On September 12th, I deposed Vivian Baker, Blake Lively's makeup artist. True and correct copies of excerpts from the transcription of Ms. Baker's deposition are attached and incorporated as A here too. On September 18th, I deposed third party Warren Zavala. It's Zavala here. I must have got it wrong first time. Ms. Lively's talent agent and WME. True and correct copies, blah, blah, blah. On September 19th, I deposed third party Danny Greenberg, Justin Baldoni's former talent agent at WME, and that's attached there. So, like I say, some of the things weren't available to me on the docket related to this, whether that's because they are sealed or they're just not available yet. So I might be flying a little bit blind with some of this, but let's go through it. So this is Wayfarer's opposition to Blake asking for treble damages and punitive damages. And we'll see where we get with this. So let's have a look. For the second time, Blake Lively seeks draconian relief under a new California statute, 47.1, which creates a qualified privilege for any person claiming sexual harassment under defined California statutes, including FEHA and California Civil Code. Let me just blow that up a little bit. I always have to think with this one. Is it Federal Employment and Housing Act? I think it is, isn't it? I always want to say association, but that can't be right. I'll just blow it up a little bit more. Let me see if I can move that so it's not in my way. Right, so section 47.1 authorises an award of reasonable attorney's fees, treble damages, and punitive damages for a failed defamation claim against a party asserting SH claims without malice and with a reasonable basis to file a complaint of SA, harassment, or discrimination. Thus, whether the privilege and remedies afforded by 47.1 apply, turn not on the Wayfarer party's underlying conduct, but on Lively's motive and intent, i.e., whether Lively asserted the claims without malice and with a reasonable basis, factual issues that remain to be tried in the main case. As explained in section 2A below, section 47.1's express language raises multiple constitutional concerns which have not been addressed by any California or other court, including its curtailment of free speech and the litigant's right to petition guaranteed by the First Amendment, as well as potential violations of the Fourth Amendment's prohibition against excessive penalties, treble and punitive. Further, Lively does not explain why California's presumption against, I'll come back to that bit, against extraterritorial jurisdiction does not apply to section 47.1 when Lively is not a California resident and the alleged harassment, which is the basis for her claims, occurred in New York and on the New Jersey set where It Ends With Us was filmed. And if you remember, Charles Babcock got very specific with Blake about filming and did anything occur in New York, and Blake herself admitted that maybe some of the either aerial shots or scenery shots may have been sections of New York, but like extra to day-to-day business on the set. So he who was Jed's attorney, got very specific about getting her to clarify that. So the footnote here says the statute also applies to claims for violations of certain sections of California's education code, which are inapplicable here. Baldoni's William Morris Endeavour agent Danny Greenberg testified. If only we could know that. Section 47.1, which took effect on January 1st, 2024, has not been addressed in a single published judicial decision. Thus, any decision by this court on the interpretation and applicability of section 47.1 would be of first impression. Can you imagine? Would there ever be a judge on this earth that would truly want to make Blake Lively the poster child for bringing section 47.1 into effect in a manner of declaring a decision for treble damages and punitive damages? Do you think Blake Lively's case is actually the one that's going to go down in history as the one where that happened, where it was applicable? So Lively, the statute, and its legislative history are also silent on whether these remedies are available for dismissal of a consolidated complaint. Exactly, there's that many parties involved here, isn't there? Where the issues of liability and punitive damages have not yet been determined by the trier of fact. And I think this is the problem with this case, and Justin's case being booted out of it earlier, because from what I understand, that got booted out on issues of law. They haven't got to the point of a jury, so they're not looking at fact issues, are they? They're not looking at evidence and things like that. It's like Justin's got dismissed on points of law, really. So this is a very important thing. So the extreme remedies created by 47.1 require factual findings that Lively asserted her claims without malice. And that's what people are going to have to testify on, isn't it? Whether there was or wasn't malice in what she said, whether she intended it to cause damage to Justin and elaborated on it in effect. And with a reasonable basis, this inquiry turns on Lively's motives, to wit, whether her complaints of SH were made with malice and with a reasonable basis, factual determinations within the province of a jury or the court on summary adjudication based on admissible evidence. No trier of fact has made these factual determinations, which are central to the Wayfarer party's defence and will be ultimately determined in the still pending main action. Just roll it up a bit. Although Lively contends that to be effective, the remedies should be imposed at an early stage of the litigation, neither the statutory language nor its legislative history address the dismissal of a consolidated complaint before the complainant's SH claims are tried in the main action. So Lively nevertheless contends that 47.1's remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. This is, she stated it in 748.1.2. Here, however, neither the dismissal of the Wayfarer party's defamation claim nor an award of penalties under Section 47.1 would achieve this statutory goal of preventing ongoing protracted litigation. As I said in an earlier video, if bringing 47.1 into it was so that she didn't get involved in protracted ongoing legal litigation, it's like a dead argument, isn't it? Because she caused it anyway. So over the same factual issues which determine the applicability of 47.1, to wit, we're doing a lot of to wit to who today, to wit whether Lively's claims are valid. What does that say? Yeah, about the cases being consolidated. So no California court has provided guidance on this issue, including whether a court's determination before trial in the context of 47.1 of the complainant's motive and intent would divest the defendant of his right to a defence at trial or by summary adjudication based on admissible evidence. The application of 47.1 to the dismissal of a consolidated complaint while the main action is still pending also raises the spectre of inconsistent outcomes. For instance, if this court applies 47.1's privilege and remedies at this early juncture, what happens if a jury later finds her claims lack merit? Nor has any California court explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the trier of fact. It's like basically she's asking for a number to be plucked out of thin air, because without a judgment based on the facts and a determination of a cost or a fee or a penalty, how do you treble it? It's like asking you to multiply zero, basically, almost, isn't it? Or just pull a number from thin air. So Lively, in fact, does not directly address the key issues of her motive and intent, but deflects by recycling the full breadth of her allegations of the Wayfarer party's purported misconduct, which are the basis for pending Rule 11 and New York Rule of Professional Conduct 3.6 sanctions motions. Oh my goodness. The bulk of these allegations have no bearing on the discrete factual issues relevant to a 47.1 analysis, specifically whether Lively had a reasonable basis for her sexual H claim, nearly said it, and acted without malice in asserting it. I mean, her whole, as we've said before, her whole argument for this rests on that poor Justin saying she's truly one of those people that believes she's right, you know, so that's where her whole claim of not having malice, of not doing anything with malice, rests on a quote from Justin Baldoni, nothing to do with her. So she can't prove malice without words from Justin Baldoni's mouth, basically. For instance, Lively argues that the court dismissed the Wayfarer party's defamation claim against Ryan Reynolds and Leslie Sloan for failure to plead malice, sufficient evidence of a smear campaign, and strong evidence that the Wayfarer party spread negative stories about Lively. Whether the court found that the complaint failed to plead malice sufficient to state a defamation claim against Ryan Reynolds, Leslie Sloan, or the New York Times, or spread negative stories about Lively is irrelevant to Lively's motive and intent in asserting her SH claims. like we've already always said, the frustration all along is why we're talking about defamation and retaliation when surely the main point of her focus should be the fact that she was SH'd. That should be the thing that bothered her more than anything, and it never has been. So, and the court did not dismiss the Wayfarer party's defamation claim against Lively for failure to plead malice. Rather, the court found that Lively's complaint, the only basis for the defamation claim asserted in the cross-complaint, was privileged under California's litigation and fair report privilege, and thus it was unnecessary to reach the issue of malice. So it was never determined whether it was malicious or not. Notwithstanding Lively's exhaustive rehashing of the full breadth of her allegations, the motion before the court remains short on the relevant factual issues and devoid of legal authority that might allow the court to award the punitive remedies provided in 47.1 at this stage of the litigation. Lively's motion should be denied because, among other things, Lively fails to show that 47.1 or California Civil Code 3294, the punitive damages statute, have extraterritorial application. She wants to use them willy-nilly wherever she chooses, basically. Lively fails to present new facts or law that might warrant reconsideration of the court's previous denial of relief under 47.1. If you remember, Liman specifically said when he dismissed Justin's case that he wasn't doing it under 47.1, and he said that he hadn't considered the amicus briefs that were presented in support of Blake claiming 47.1 either. No trier of fact has found, based on admissible evidence, that Lively's SH claim were asserted without malice and with a reasonable basis. They still have to determine that. And Lively fails to show, and no trier of fact has found, clear and convincing evidence that the malice required for punitive damages as required by Section 3294, and plaintiff has not proven, and no trier of fact has found, the actual compensatory damages required as a basis to calculate treble or punitive damages. So it's highlighting to Liman that they haven't looked so far, everything that's been decided on, there's not really been looking at the facts or any evidence or anything that's come from a deposition or has factually been proven to be true, which either comes down to a request for summary judgment from one party or another, or it going to a jury where facts can be looked at, isn't it really, I guess, would be my understanding of it. So plaintiff's motion should be denied. No California or other court has addressed the constitutional concerns and conflicts apparent from the face of Section 47.1. It'll be interesting to see if anything comes of this once if it's ever resolved, what happens with 47.1, because it's kind of a bit stupid if it's there and nobody ever uses the thing and it's purely always there. Just, I mean, it kind of beggars belief, doesn't it, really, that Blake could do that CRD and Justin wasn't allowed to respond to it, and she could then go to the New York Times with it and use it to back up an argument for that article, and he can do nothing about it. And other than that, 47.1 seems to be completely useless because nobody wants to implement it and nobody wants to accord damages using it. It's, what is the point of it, really, other than to penalise people that may have been falsely accused of doing something? Plaintiff's motion implicates two California statutes, Civil Code 47.1, which applies to SH claims, SH claims under certain enumerated California statutes, including FEHA, and Civil Code 51.9 and Civil Code 3294, California's punitive damages statute. Lively seeks remedies under Civil Code 47.1, which provides for severe penalties for unsuccessfully filing retaliatory defamations action against SH and retaliation complainants. According to plaintiff, the recently enacted Section 47.1 was intended to deter frivolous claims that force survivors to defend against long and expensive retaliatory defamations lawsuit by imposing significant remedies for success defendants in defamation claims, and was intended to protect victims from the litigation itself. As a preliminary matter, Lively does nothing to address the constitutional concerns and conflicts raised by 47.1's express language. First, it conflicts with the right to free speech and petition guaranteed by the First Amendment to the United States Constitution. There's some case law cited there. It also clashes with the Noah-Pennington doctrine, which provides that those who petition any department of the government for redress are generally immune from statutory liability for their petitioning conduct. More case law there. By imposing a statutory penalty on plaintiffs for unsuccessfully bringing certain types of lawsuits, even when they do so in good faith, Section 47.1 appears to trespass on the Noah-Pennington immunity doctrine. Let's bring it up a bit. Second, plaintiff fails to address how 47.1 can be reconciled with California Civil Code 47B, which, consistent with the right to petition, creates an absolute bar to any defamation claim based on statements made in connection with a judicial proceeding. Specifically, 47B applies to any communication, 1, made in judicial or quasi-judicial proceedings, 2, by litigants or other participants authorised by law, 3, to achieve the objects of the litigation, and 4, that have some connection or logical relation to the action. So just looking at the footnote there, Civil Code 51.9 extends liability for SH beyond employers to those with a professional or business relationship with the complainant. So we've got some case law cited there. So the privilege is absolute and applies to all publications, irrespective of their maliciousness. So that implying, I guess that's looking at the New York Times, isn't it? I mean, because that's what I said in an earlier video, is that I don't believe that 47.1 was designed for women or men that are the victims of SH to be covered so that people couldn't retaliate against them or come at them with defamation or whatever it may be. But it didn't mean go out and contact the New York Times and have them plaster your version of events all over the place. We're going to cover you for that too. I don't believe that was ever the idea behind 47.1. So let's move down a little bit. So it protects to publications made outside the courtroom and all torts except malicious prosecution. Undergirding the immunity conferred by Section 47B is the broadly applicable policy of assuring litigants the utmost freedom of access to the courts to secure and defend their rights. More case law cited there. It is desirable to create an absolute privilege, not because we desire to protect the shady practitioner, but because we do not want the honest one to have to be concerned with subsequent derivative actions. So third, plaintiff fails to explain how 47.1 should or can be applied when, as here, a defamation claim is dismissed at the pleading stage before the dispositive factual issues of whether plaintiff's claims were asserted with malice and without a reasonable basis, issues of fact within the province of the jury. I mean, we all moaned about that at the time, didn't we? Why is Liman acting as the jury in dismissing Justin's case when he's not looked at any of the facts, any of the evidence, when discovery is not complete? How can he rule on it when he doesn't truly know? He's just looking at the points of law. In the same vein, Section 47.1's approach to punitive damages under Civil Code 3294 is particularly troubling. As explained in Section 11E below, California has a long-standing rule that there is no right to punitive damages. Rather, punitive damages require clear and convincing evidence of malice, a determination left to the discretion of the trier of fact based on admissible evidence. And I don't think Baldoni's worried about being found to be malicious in bringing his lawsuit against Blake. So where a trier of fact finds that punitive damages are warranted, the Fourth Amendment's prohibition against excessive penalties limits such damages to a maximum of 3 times the actual compensatory damages awarded by the jury. The questions of whether 47.1 permits punitive damages to be awarded as a matter of right, or how punitive damages would be calculated absent an award of actual damages, where a defamation claim has been dismissed on a motion to dismiss, have not been answered or even addressed by any court. So nor does plaintiff explain, much less cite authority, for how the court can calculate punitive or treble damages without an award of compensatory damages. And it's as we've said before as well, you know, people think it's simple calculating this damages thing, but what they don't, often people don't understand is that every decision she's taken in fighting this case will be looked at in terms of, was this a sensible use of funds in order to fight this case? Should the other side be liable to pay this? Was this actually unnecessary to cause this cost? And as we've seen throughout Blake's case, she's been willy-nilly bringing all kinds of motions, whether it be for sanctions or asking for permission to submit a letter or subpoenaing content creators or asking for things to be transferred or whatever it may be. Everything to do with that will be looked at, even in terms of if she should win. It's not a given that she'll get everything that she wants to get, and that may take years to be figured out as well. So the plethora of serious constitutional and other legal questions have not been addressed by any California court, raising the preliminary question of whether this court, as a matter of first impression, should apply 47.1 to impose the draconian remedies of attorney's fees, treble damages, and punitive damages without any answer to or even guidance on these critical questions and concerns. It may have been for some or all of these reasons that the court has already declined to award Lively the relief she sought under section 47.1, albeit without prejudice. In so doing, the court explicitly noted that it had not ruled on whether Lively's statements were privileged under Civil Code 47.1, and that if Lively chose to renew her motion, she should fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. So in brackets here, the court did not rule on whether Ms. Lively's alleged statements were privileged under section 47.1. While Lively now resuscitates her motion with an extensive exposition of the facts asserted in prior pleadings and the order, she does not cite new facts or law relevant to whether she had a reasonable basis for her SH claims and whether her claims were asserted with malicious intent. Simply put, nothing has changed since the order and Lively, and this renewed motion appears to be nothing more than an improper request for reconsideration. It is another of those instances where it's like she's foot tapping in the background. She's like, this has to move now. This has to be on my time scale. I want this now. We've seen this all along. It's like the amount of times that she's argued about what she hasn't got from people and completely ignoring the fact that the deadline is not even near. But it's like, I want this now. So I'm going to write the judge a letter and say, I haven't had this now and I'm getting frustrated. And that's kind of another symptom of her problem, isn't it, really? So where did we get up to before I started tapping on things? Seemingly, so it's another improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public perception and the potential jury pool. At best, the motion is premature. This court should decline Lively's invitation to interpret 47.1 as an issue of first impression in the dearth of any guidance from the California court and impose heavy-handed penalties, which would require this court to make premature factual determinations. Can you imagine if in future people were quoting Lively versus Wayfarer in terms of getting treble damages and stuff. At Lively versus Wayfarer being the citation that justified entitled people to get more money from people who were merely trying to defend themselves. So plaintiff fails to show that 47.1 or Civil Code 3294 may be applied extraterritorially. And he only said extraterrestrially. that wouldn't be out of, if she could get some evidence or a piece of deposition from another planet at this point, I think Blake would possibly go to those lengths if she could find like ET responsible or something like that, or part of the untraceable smear campaign. There might be a subpoena in the works for him. The threshold question is whether these California statutes have extraterritorial application where, as here, the plaintiff is a resident of New York and the underlying conduct occurred in New York and New Jersey. The California legislature knows how to create exceptions when that is its intent, and when a statute gives no clear indication of an extraterritorial application, it has none. So we've got case law cited there. California recognizes a presumption that the California legislature did not intend a statute to be operative with respect to occurrences outside the state unless such intention is clearly expressed or reasonably to be inferred from the language of the act or from its purpose, subject matter, or history. More case law cited there. And in brackets, it states when a statute gives no clear indication of an extraterritorial application, it has none. And another bit there, Ward versus United Airlines, where it's presumed that state law is intended to apply only within state borders, and courts ordinarily will not give extraterritorial effect to legislative enactments absent an affirmative indication that such was the legislature's intent. I think it's a good news that they're quoting a lot of legal citations, because we know Liman likes to have umpteen legal citations when he's either considering anything or delivering anything in terms of an order. So in brackets here again, the presumption against extraterritoriality is one against an intent to encompass conduct occurring in a foreign jurisdiction in the prohibitions and remedies of a domestic statute. And another one here to do with the Federal Employment and Housing Act should not be construed to apply to non-residents employed outside the state and when the tortious conduct did not occur in California. An extraterritorial application of FEHA would raise serious constitutional concerns, as the Commerce Clause precludes the application of a state statute to commerce that takes place wholly outside of the state's borders, whether or not the commerce has effects within the state. So let's just roll that up a bit. So although proposed, I don't know how to say it properly, amici curiae offered in support of Lively's position quote extensively from section 47.1's legislative history, Lively does not point to express language in 47.1 or any portion of the legislative history that even hints at an intent that the statute have extraterritorial application. In fact, it does not include any affirmative indication that it was intended to apply to conduct outside of California. Likewise, nothing in the legislative history of 47.1 indicates the legislature had any intent for this statute to operate outside of California, because section 47.1 is silent on the geographic scope of its application, and there is no expression of legislative intent for it to apply extraterritorially. The presumption applies in full force, and Lively, a non-resident of California, cannot invoke it for conduct occurring outside California. So there's some case law quoted there in brackets dismissing Labour Code section 223 and other claims, holding that plaintiff's attempt to represent non-California individuals fails because she has not alleged how any putative class members working outside of California can recover under the California Labour Code. And we've got more case law quoted there to do with extraterritorial applications of California Code, Whistleblower Protection Act, more Labour Code stuff that didn't apply. So by contrast, where the California legislature does see fit to provide for the extraterritorial application of California statutes, it says so. So that's interesting, isn't it? So we've got a bit of code here. Extending workers' compensation to certain employees who are injured while working out of state. So it's lacking a bit of that, is the argument. It's not saying that this can apply outside of California. Absent the express or implied showing of an intent of extraterritoriality, Lively must establish a substantial connection between the situs of the legally relevant conduct and California, specifically the location of where the core of the alleged wrongful conduct occurred. I guess that's why Babcock was getting really specific in terms of Jed Wallace and that as well, but it was really for the good of all, for the greater good. I was watching Hot Fuzz again last night, and if you've seen Hot Fuzz, don't want to spoilers, but the neighborhood watch or whatever it is, the mantra was the greater good, and they all reiterated it as one. But yeah, that's the feeling here, isn't it? That this was where did it occur? Where did this so-called SH occur? Where did Jed Wallace supposedly defame you, kind of in reference to New York, I guess, and clarifying what legislation she's trying to present as well in her arguments. It's relevant to all the parties, isn't it? All of the separate Wayfarer parties. So a formulaic, conclusory blanket recitation of ratification is insufficient to overcome the presumption, absent facts sufficient to establish a factual nexus between the defendant's California-based activities and the allegedly wrongful conduct. So case law there. Nor does a contractual choice of law provision overcome the presumption that a California statute lacks extraterritorial reach. More case law, where it was dismissing FEHA and California Labour Code claims asserted by a non-California resident who failed to establish a nexus between the allegedly wrongful conduct and California. That's kind of been Blake's problem all along. She forum shopped in order to get the job done, but now she's having to deal with the ramifications of that, but she kind of has to pull connections from somewhere. You can't just forum shop and not connect the dots, is what they're saying. There has to be some crossover as to why it should apply. Neither Lively's complaint nor the motion state facts sufficient to establish a substantial connection between the Wayfarer defendant's unsuccessful defamation complaint filed in and dismissed by a New York court or the underlying SH claim which would give rise to the privilege she seeks to invoke. Lively is a New York resident. The core conduct alleged SH on the ends with us set, and the filing and dismissal of the Wayfarer party's unsuccessful defamation claim, the basis for Lively's request for remedies under 47.1, did not occur in California, but in, and it's clarified, it's blanked out there, according to Ellyn's declaration. While Wayfarer is headquartered in LA, the employee or employer's residency is not sufficient to overcome the presumption when the tortious conduct is outside of California. Case law stated there, which boiled down to California residency is insufficient to defeat the presumption against extraterritorial application of California law. The failure to demonstrate a substantial connection between the situs of the, I hope I'm saying that right, situs, I think it must be, I'm not saying situs, of the core conduct and California defeats any notion that sections 47.1 or 3294 can be applied extraterritorially. See that case Rulans 2013, where it was found that even though the plaintiff was a California resident, she worked in Nevada and her employment was terminated in Nevada, so her alleged California residency was insufficient to defeat the presumption against extraterritorial. Can we stop saying extraterritorial? I'm going to have jaw-ache. Application of California law. And more case law cited there, holding that the concept of extraterritoriality applies regardless of the plaintiff's residency. All right, let's flip down a bit. And basically more just saying the same thing. But I think this is all good news because, as I said, Liman likes to be bashed over the head with case law. I think he's like a case law nerd, isn't he? I think he likes to go off and look at these things for himself. I think he likes to go off on a research thing or send some of his poor lackeys off to go and do it on his behalf. I'm not sure which. And there's a patch there, this Russo case, finding that FEHA did not cover the plaintiff, even though she was a California resident. Dismissing FEHA claims because the conduct giving rise to those claims, comments made in Florida, occurred outside of California. Right, because you cannot overcome the presumption against extraterritorial application of 47.1, Lively's request for relief under it should be denied. Section 47.1 cannot apply where, as here, there are no factual findings that Lively's claims were asserted without malice and with a reasonable basis. So it's like she has not proven that she screamed SH, that SH actually happened, and that she's a reasonable basis to say those things in regard to Justin Baldoni. Section 47.1 creates a privilege for communication made by an individual without malice regarding an incident of SAH or discrimination is privileged, so long as the speaker has, or at any time had, a reasonable basis to file a complaint of SAH or discrimination. The Wayfarer defendant's defamation claim was dismissed pursuant to Rule 12b(6) for failure to state a claim. The order dismissing the claim expressly states that the court did not consider whether the Wayfarer parties pleaded malice, but dismissed the claim based on privilege grounds. Plaintiff's harassment claims remain pending, and the merit of those claims, as well as Lively's motive and intent in asserting them, will ultimately be decided by a trier of fact, a jury, or the court in the context of summary adjudication. Indeed, a centrepiece of the Wayfarer party's defence is that Lively's claims have no merit and were asserted for an improper purpose. The jury must resolve the threshold question of the defendant's knowledge of facts on which his or her claim is based. I mean, in a way, if you just look at it kind of as a bit of an observer, the whole SH claim basically could have been brought into play simply just to gloss over everything that Blake actually did on that set, all of her missteps, all of her assumption of power, the stealing of power, the threats, her claiming SH and having that CRD just meant nothing to her, or she may have been advised that in doing that, none of her actions could then be examined. So it was like a whitewashing in much the same way she used Taylor Swift's name over everything. It's kind of, you can't say anything if Taylor's involved. You can't possibly win against Taylor because Taylor's too well supported. Nobody's going to believe you because I've got Taylor Swift on my side. It's a bit like that kind of thing. The whole SH is more just about smokescreen, isn't it, really? The plaintiff does not explain how the court might eliminate the risk of inconsistent findings on the pivotal issue in this case, because nothing would have happened, you know what I mean, without her claiming that. Where's the defamation and retaliation? Lively's harassment claims, should this court prematurely decide that Lively's SH claims were asserted without malice and with a reasonable basis. Nor does plaintiff provide any authority for the notion that the Wayfarer defendants can be stripped of their rights to a defence at this early juncture in the context of a Section 47.1 motion. Lively similarly fails to identify new facts that might support her motion. Plaintiff merely resuscitates the allegations set forth as the basis for plaintiff's pending motions for sanctions under Rule 11 and New York Rule of Professional Conduct 3.6. And that's the frustration, isn't it, really? She keeps doing this, keeps reiterating arguments that have already been submitted that haven't been ruled on yet. And it's that thing of I want it now, speed it up. It's because she knows she's running out of time before this all goes tits up, before everything's revealed. So Blake's case requires speed. The bulk of the allegations have no relevance whatsoever to this motion, which is not about the Wayfarer party's motives or conduct, but about Lively's motive and intent. In fact, Lively's motion is laden with extraneous and irrelevant facts. For instance, Lively argues that Wayfarer's defamation claims against Ryan Reynolds and Leslie Sloan were dismissed for failure to plead malice. Lively ignores that even assuming a pleading defect can be the basis for Section 47.1 remedies, the court did not base the dismissal of the Wayfarer party's defamation claim against Lively on this ground, but rather on the ground that it was subject to California's litigation privilege and the fair report privilege. I mean, I guess for those of you that want to think that Liman is biased, and I'm kind of saying nothing to something about that at this point, but say worst case scenario, he's kind of found himself backed into this corner and pressure of some kind is being exerted from him. He still wouldn't want to be the judge that rules on this, that rules on whether this can be enacted. So say he was biased, he would still have to play a very careful game in which he appears to allow her an awful lot of leeway, but at the same time, the end result still works in his favor, and he doesn't look like a complete chump. So he had. So for those of you that want to believe in him being biased, I still don't think he will allow her to win the case if it makes him look like a complete and utter idiot, and it can be overruled with ease. So he may have taken a payoff if you want to believe that he's taken a payoff, but I still think he can't possibly, it's my personal opinion, allow her to win. And I could be wrong, but that's what I'm saying. So plaintiff has not proven that she is entitled to punitive damages under 3294. While a plaintiff who proves his case is always entitled to actual damages, a plaintiff is never entitled to punitive damages as a matter of right, not even upon the clearest proof of malice in fact, Sumpter versus Matteson, where it was rejecting the contention that punitive damages may be assessed as a matter of law. For an award of punitive damages under California Civil Code 3294, a plaintiff must prove by clear and convincing evidence that the defendant acted with malice, oppression, or fraud in bringing their defamation cross-complaint. Malice is defined by Section 3294, subdivision, blah, blah, as conduct which is intended by the defendant to cause injury to the plaintiff, or despicable conduct which is carried on by the defendant with a willful and conscious disregard of the rights or safety of others. Despicable conduct is conduct that is so vile, base, contemptible, miserable, wretched, or loathsome that it would be looked down upon and despised by most ordinary, decent people. Justin Baldoni, Blake Lively, Justin Baldoni, Blake Lively, Justin Baldoni, Blake Lively. Such conduct has been described as having the character of outrage frequently associated with crime. Which is interesting, isn't it, given that Baldoni has brought in a couple of what might be more termed criminal attorneys. I still think that there may be an element of, are they trying to compose some kind of criminal case, the Wayfarer side, in some way? There's little hints here and there that's like, is it? It's interesting, this. So conscious disregard means that the defendant was aware of the probable dangerous consequences of his conduct and that he willfully and deliberately failed to avoid those consequences. Let me just move that up for a bit. So case law cited there with the citations omitted. Put another way, the defendant must have actual knowledge of the risk of harm it is creating, and in the face of that knowledge, fail to take steps it knows will reduce or eliminate the risk of harm. In the defamation context, To show actual malice, plaintiffs must demonstrate a defendant either knew his statement was false or subjectively entertained serious doubt his statement was truthful. So we know that Justin Baldoni believes he's telling the truth. He believes that he put everything, including the context around those text messages, out on his website for the whole world to download. He wanted the truth out there. He wanted it to be examined and picked apart in detail. The clear and convincing standard presents a heavy burden far in excess of the preponderance sufficient for most civil litigation. So the burden of proof by clear and convincing evidence requires a finding of high probability. The evidence must be so clear as to leave no substantial doubt. It must be sufficiently strong to command the unhesitating assent of every reasonable mind. More case law, where it was clear and convincing standard, requires a finding of high probability, so clear as to leave no substantial doubt, sufficiently strong to command the unhesitating assent of every reasonable mind. So whether a defendant acted with malice is an issue of fact for the jury, and it is within the exclusive province of the jury to say whether or not punitive damages shall be awarded, and the granting or withholding of punitive damages may not legally be influenced by any direction of the court. So more case law there. Although on this record, the imposition of, so this is what it boiled down to, although on this record, the imposition of punitive damages would have been permissible, it was the jury's exclusive prerogative, after being duly instructed, to find defendant acted without malice and thereby decline to award punitive damages. So we're a long way from that, is basically what they're saying. She's jumped in way too early. This can't happen at this point. Plaintiff simply ignores the requirements that malice be proven with clear and convincing evidence. Any finding of malice and punitive damages is within the exclusive province of the jury, and the court is prohibited from influencing the jury's decision on whether to award punitive damages. Instead, plaintiff avers that A, for punitive damages, the record as it currently exists is sufficient for the court to determine the Wayfarer parties engaged in oppression, fraud or malice by bringing or maintaining their claims against Ms. Lively. This argument, while facile, is contrary to the law. Do some people say facile? I think we say facile in the UK. But we see with Blake's evidence, don't we, what she considers oppression, fraud and malice is the likes of that communication chain when they were launching the lawsuit, the website, the lawsuit info website, when they were just communicating backwards and forwards saying, can you see it? Can you see it? It's not showing the pictures like this. My wife's device is different to mine. We're getting different things. What can we do about it? She thinks that's the messages between them, and they're making that website that was literally just the publicly available documents. She is calling that part of the oppression, fraud, malice. That's her evidence of oppression, fraud and malice, that kind of thing. And the text messages, the other kinds of text messages that we've seen where we've all looked at them and said, why does Blake Lively think these messages support her case when they clearly support Justin's case? You know? So how far, we're nearly there. Plaintiff fails to explain how, in the absence of actual damages, the court can calculate punitive or treble damages. Punitive damages typically require a finding of actual compensatory damages. An exception exists where a plaintiff is entitled to recover presumed damages. Neither Section 47.1 FEHA nor Title 7 provide for presumed damages. Hence, an award of actual damages is a predicate for any award of punitive damages. There has been no award of actual damages after a trier of fact has found liability. Plaintiff similarly fails to explain how the court can calculate treble damages absent a finding of actual compensatory damages. Put another way, what exactly would the court be trebling? Conclusion. For the foregoing reason, the Wayfarer parties respectfully request that the court enter any order denying Lively's motion for relief under Section 47.1. So I think that's pretty excellent. So it's signed by Ellyn Garofalo, and we've got Kevin listed under there and Brian and all of that. But I think that was pretty excellent myself. And I think it speaks to what Lyman likes to see, I would say, as well, in terms of how he likes his evidence presenting. Um, so let's just have a look and see. I just made some notes, so I just wanted to have a quick flick and see if there was anything. So the main points basically. California law doesn't apply here because she lives in New York and the conduct on the set happened um, in New Jersey, allegedly for the most part, didn't it? This business of extraterritorial reach, that it's not explicitly stated in that 47.1 how it would be used extraterrestrially, extraterritorially. And they've made plenty of arguments to say that if it's not specified how it is used out of state, they've presented lots of legal citations for other similar circumstances where it could not be used because it wasn't stated how it would be used. So a big part of it is also the fact of how can you calculate punitive and treble damages without an awarding of damages in the first place to work off of. And obviously it's highlighted the fact that 47.1 has never been actively used in this way, and that there is, and that maybe that is because there are obvious clashes with the First Amendment and things like that. So I think that is it. Other than that, they've kind of highlighted, haven't they? They've kind of got a tiny dig in about that part of it may be just more subterfuge, really, just trying to alter public perception. I mean, it gave us some headlines for a few days. I know it's funny, isn't it? I know like people have gone on about the Gossip Girl photos in the last few days, and some people have said, oh, look, it's like she's going through boxes of old photos. Is she packing up? Is she divorcing? But it could be just as reasonable to say that the whole family is moving somewhere. I think, wasn't it so long since they reckon that they bought a whole new compound or something somewhere? So the whole family might be moving. It's not necessarily that Blake is splitting up or anything like that. But I think it does, how she chooses to get the headlines on her side. Never forget how problematic it has been in terms of the kind of things that she thinks it's okay to do. I mean, she's used a photo of Michelle Trachtenberg again, a behind the scenes photo, and there was lots to say, wasn't there, that Michelle Trachtenberg was no fan of Blake Lively's. And just remember at the time of Michelle Trachtenberg's death, how Blake put out that really weird post about Michelle being well known for her yummy caramel lip gloss, and everybody's saying, is that actually to alter the SEO? Because there's so much about the yummy and ball busting out on the internet that she's actually used somebody's tragic death, the passing of a very young, a relatively young person with a lot of life ahead of them. Has she just used that for SEO strategy? And that takes a certain mindset in order to do that. And there was an argument to say it was a very odd comment to make about somebody that has just passed. Out of all the things that you might pick out about them that were a fundamental part of how they were perceived by the world, was the yummy caramel lip gloss. And I think that's what we've all to remember about who we're dealing with. And when we're talking about the question of malice or not malice, and how bullheaded she is, and how she will never see the opposite side of an argument, and how everything has to be on her terms. And it's a big wake up to anybody that's beating themselves up over dealing with a narcissist and questioning why they can't just get them to see the way it is, and continuing to try and argue the point with it over and over, and staying too long in a relationship with a narcissist and not just walking away or whatever it is like, this case is for you out in the wild to see this is exactly what it's like to deal with a narcissist or somebody who just will not listen regardless of what the facts say. Nothing is off the table in terms of what they will say to you, what they will accuse you of, what they will do behind your back, how they will try to segregate you from the people that love and care for you in your life. Nothing is off the table when it comes to them. And this is what you have to bear in mind. That's why we've all had so many frustrations with this case, because if you're reasonably logical, you're reasonably moral, you will not understand Blake Lively's actions. You will not understand being so egocentric, so only seeing your single perspective on things, you know? So yeah, so it would be interesting to know what Vivian Baker, Blake's makeup artist, what Warren, her talent agent, and Danny Greenberg, Blake's Justin's former agent, have all said in their depositions that back up this opposition. So yeah, so I think that's it for today. That was long enough, really, wasn't it? I hope you've enjoyed it. I hope it didn't go on too long, but I haven't done you a video for a few days, so I thought it was worth doing properly and in its entirety. But if you have any comments, please do drop them for me, and you know I'll do my best to reply. That was the postman just delivering my post. Yep, please do hit that like and subscribe and share if you can, and I'll keep an eye on the docket and see if anything's unsealed or if some of these mystery documents that won't let me have them just now will be revealed. But I hope you enjoyed that, and I will see you again soon.